Y'all got enough? Okay. All right, Ms. Winston, if you come, Ms. Winston, yeah, come on up, please. I assume you sat through some of this?
A little bit.
Seen the procedure that we utilize?
Yes, sir.
Okay. You have any questions before we get started?
Is there any time for rebuttal in my 15 minutes or no?
Yes, ma'am. What you can do is, you're the appellant here.
Right.
So you have 15 minutes. You can use up to 5 minutes of your time. We can reserve that for rebuttal. And what we'll do is that'll be contained when we, on the lighting system. Is that what you want to do?
Possibly, yes. I don't think I have a whole 15 minutes here.
Okay. What I'm going to need for you to do, though, is to tell me on the front end how much time you want to reserve.
5 minutes will be fine.
5 minutes?
Yes, sir.
Okay. In just a moment, we're going to start this process, and the lights will come on. What I need for you to do is tell us your name and tell me how much time you want for rebuttal, and then you can just tell me whatever you want to about this.
Okay.
Once you finish your argument, the appellees will get to make their argument.
Yes, sir.
Once they finish, then you can come back and do your rebuttal. Okay? And at the end of the day, we're not going to issue a oral decision. What we will do is write an opinion and send that out to you.
Okay.
Okay?
Thank you.
All right. Anything else?
No, I don't think so.
Okay. All right. If you'll tell us your name and how much time you want for rebuttal.
Good afternoon, Your Honors. My name is Allison Winston. I would like to have 10 minutes to speak.
Oh, you want 5 minutes for rebuttal?
For rebuttal, yes, sir.
Okay. All right. You may proceed.
I am the middle daughter of Robert and Betty Winston here in Jackson, Tennessee. I was a caregiver and conservator of my mother for 6 years, 24/7, and with no help. I do have 2 other siblings. I am requesting first that the court will allow me to do a statement of evidence in my case. I'm obviously not an attorney. I was not aware last summer that I needed to have a statement of evidence if I disagreed with Judge Morgan's final judgment. So I'm requesting that if possible. There were no transcripts or court reporters, but I would appreciate a chance to do that if possible. Judge Jimmy Butler here in Jackson, Tennessee, believed that I was the best person in 2019 to do the job as conservator for my mother. His opinion is included in my brief. He became very familiar with me as I had siblings return 5 different times to court to try to get the conservatorship away from me. The reason why this is important is I won 5 times, and I also won in Shelby County's appeals court. So I can't say enough about Judge Butler in protecting my mother and also for believing in me and that I was the best choice for her. After 32 years of living in Los Angeles, I moved back to Jackson to take care of 2 parents. I left here at 18, so there were a lot of adjustments, but I felt the best thing to do was to come take care of my parents. I had won a wrongful death lawsuit with my lawyers in Shelby County, and everyone in my family received money, including my mother, but my mother never got to see hers because she passed away. And this money is what is in question today, is $9,000, and State Farm, of course, is trying to get this money, and I am technically right now unemployed and would prefer to have this money come to me. My mother always said that I was one that saved the family. I pretty much won that lawsuit and for the last 2 years handed money to my siblings and of course looking out for both of my parents. I was certainly not trained or educated by my lawyer or by the courts here locally about the do's and don'ts of conservatorship here in Tennessee. I received a 2-page document that I brought with me today about just what I was over as far as my mother's estate, but and in the meantime of that, my father passed away, so there was never any, you know, if you borrow money from the estate, you've got to let the courts know. I had no idea I was flying, you know, solo on this. Every decision I made was to ultimately protect my mother. I know today you will hear that I stole money, that I was a thief. All these I've been called a thief so many times in court, it's just absurd. But I did not receive any compensation as a caregiver or as a conservator, and I did both jobs. I had many expenses of my own. I was still working remotely with the company in Los Angeles that I had been working for. I was paying for funerals by myself. I was paying for medical things, both for my father and my mother, and I never got, compensated for any of that. I didn't ask for compensation. When I got my mother the aid in attendance, my father was in the Korean War, and so I went to the VA. I got her aid in attendance. We decided, Mother wanted to help me. I was helping her. And the last year where I took the money, she and I had a conversation at a kitchen sink. It was something that simple, and now it has come to an appeals court. We decided that the VA had said a family member can pay another family member. So we decided to take that money that she got from the VA. She was about 86 at that time. She lived to be 91. And we decided to pay me with that money. And never knew that we had to do anything else. My mother was a bookkeeper for 35 years with the school system here. So every decision, financially and otherwise, I went to her. Even though she had had a stroke and had taken most of her speech, that is why I became conservator and an advocate for her. She could not carry on a conversation like you and I, but she mentally was fine, and she could say words. But basically, she would not be able to speak in full conversation as I am doing.
Did at any time you apply to the court for permission or request to take a certain amount of money?
I'm sorry, sir?
Did at any time that you apply to the court for permission to take a certain amount of money?
Well, this is what I had stated earlier. I received a 2-page document, and my attorney, the courts, no one told me that I had to do such as that. I know now, obviously, but no, sir. Mother wanted to help me, so we took the money out of the VA money, which was perfectly fine with the VA. It's legal. And I would like to also point out that all of my accounting for almost 5 years was approved by Judge Butler and Judge Maroney here in Madison County. If I'd wanted to steal, I had 4.5 years to steal. And again, between funerals that I was paying for by myself and then medical expenses, I never asked for reimbursement from anyone, certainly not from my mother. I got her money. I was trying to enhance her life, and so then the last year I could not travel for work. So I had a big city job. I had to travel, so that's when I took care of my mother because I was not going to leave her. So I had bills like everybody else, and so that's when we decided to do the VA money. In the summer of 2024, the Tennessee legislature did something really good for conservators. Bill number 227 for the Senate and bill number 1993 for the House. The senators had seen that conservators in the state of Tennessee were getting in trouble because of the same reason that I got in trouble, and they were having a difficult time. This bill was passed, but unfortunately, my mother had passed away, and I wish that bill had been there for me, that conservators take an oath and they are trained. Many states here in the United States have training. Tennessee did not, obviously. The reasons for my appeal. Judge Morgan did not explain in his final order certain expenditures that were similar to Judge Butler and Judge Maroney, and they had, let those go for 5 years. He never explained what his reasoning was that he wanted me to pay the estate back. Every month I was in court with him from June 2024 to April of 2025, just over last accounting. I sought counsel from Legal Friends and also the group in Nashville that is a nonprofit for conservators. They helped me with the accounting. Everything looked great. He would not approve my accounting because of the way that it was done. So he went and hired an attorney, which, an outside attorney, he has the right to do. But I just think it's absurd, again, in conservatorship terms, as far as the, letter that was given to me on what I was over. There's no example of here's how you do the accounting. I had no training. No one really does that I know of. I feel that the state should be paid back $5,000 that the other attorney was paid because, there was nothing wrong with my attorney. I'm not, someone that can do elder, bank, anything that has to do with accounting, but I just didn't think it was fair for him to take it upon himself to hire outside counsel to make sure this accounting was done the way he wanted it. My thoughts on that was my mother's estate should not have had to pay for that. I believe that he was wrong in ordering State Farm to execute its bond of $25K. For 5 years, I went to State Farm here locally, and I got a bond. Judge Butler always said in court, I never thought that Allison would steal money, but the animosity between her siblings and her, I had to do accounting twice a year. Most conservators do it once a year. I feel he was wrong in ordering me to repay the estate, but he took it out of my money, and, again, I didn't steal from my parents, and I certainly didn't steal from my mother, and she was completely aware that, we were paying me because I wasn't working. I feel the court's order and State Farm are wrong that a conservator automatically has to indemnify a surety who executes a bond under TCA 25-3-122 when there is no indemnification laws in the bond to begin with. In conclusion, I humbly ask the court for several things. I believe that the $9,000 that's sitting in a bank here in Jackson, Tennessee, which was part of my mother's money that she got as a sole survivor of my father in the wrongful death, I think that should come to me. Not because I helped her, not because I spent money. Those are things I did do. But I don't think that State Farm, a billion-dollar company, should get a measly $9K of mine, and because everyone thinks I'm a thief. I have never been in trouble like this in my life. I do not like being here. If I had known, if I had been trained or anything, even just the sheet that the court sent out, I would have reported it in my accounting, like I did for 5 years, that, oh, by the way, I took this money out. Never did it, never knew I had to do it. How can you do it when you don't know you have to do it? I know that sounds, Judge Morgan said, well, that's not a good enough excuse, and that's all I've got.
You used your initial
Oh, have I?
time.
I'm so sorry.
You've still got your 5 minutes rebuttal.
Okay.
But we need to hear from the other side, then you can come
Okay.
back
All
and
right,
finish
thank you.
whatever you've got to say in the rest of your 5 minutes. How are y'all sharing time?
Your Honor, we're going to each take 5 minutes.
You good? Okay.
May it please the court, my name is Sarah Barnett, and I'm the substitute conservator for the estate of Ms. Winston. And I'm just going to address the first issue that the appellant has raised, and I'm going to leave the State Farm bond issue to the other attorneys. The trial court properly ordered the appellant to reimburse $33,885.25 to the conservatorship. And the appellant, explains that she did not understand what was going on, but one of the reasons that Judge Morgan really dug into this was that at the very first hearing, when he took over this case and was appointed to it, what he recognized and found in his orders, you'll see it in there, it's not just the money that was taken, it's also the fact that the interest in the family home was transferred to the appellant after the conservatorship was granted. She also made herself the trustee of the Betty A. Winston Trust, which was signed by Betty Winston after the conservatorship was entered. That trust left everything that Ms. Winston owned as part of her estate to the appellant solely, and leaving out the other two siblings. She also transferred Ms. Winston's car to herself, and then, of course, she made over $33,000 in unauthorized expenditures to herself. So it's not as simple as just not understanding. None of those things were approved by any court. And the main thrust of the argument is as to, with respect to the $33,000 that's to be reimbursed, is basically that somehow the previous orders from Chancellor Butler and Chancellor Maroney grandfathered in any kind of transactions of this nature. And that, there's no case law, there's nothing to base that on. The conservatorship scheme requires that accountings be periodically provided to the court, and each accounting is reviewed. In this particular case, when Judge Morgan was reviewing it, he was also looking at a final accounting. And in that, and another important thing happened was that the other heirs also made an objection to the accounting. And so now, under the conservatorship statutes, he's got to have a full-blown hearing on all of the accountings, on everything. And so that's different than the other accountings that were approved by the prior court. But nevertheless, even if they did have hearings, that's not what was at issue for Judge Morgan. He's looking at the accountings before him. He finds that those expenditures are not appropriate. And there's also an argument about good faith. You heard it in what she said today, and it's also in the brief. And certainly good faith is an element of the statutes, and in fact, 34-1-1112 says first that no compensation can be paid to a fiduciary without court order. We know that didn't happen. And then 34-1-113 allows for approval of expenditures even after the fact if those are on behalf of the ward and if they're incurred in good faith. The problem is that Judge Morgan did not find that they were incurred in good faith. He did not find that they were incurred on behalf of the ward because they were actually personal expenditures for the appellant. That's clear in the detailed orders that Judge Morgan had. He had numerous hearings and numerous orders, all detailing exactly what expenses were made. Some of those expenses were even made after her death and after the ward's death, and so they certainly couldn't be on behalf of the ward or in the best interest of the ward. And so Judge Morgan looked at all of the different transfers and properties. He reversed the property transfer. He dissolved the trust, I guess you would say, and he found that those expenditures were not appropriate. And I would ask the court to uphold the rulings of Judge Morgan and find that they are appropriate and should be upheld. Thank you.
Thank you.
Good afternoon, Vincent Saylor. I'm here for Russell Winston and Andrea Lewin, who were the other two children of the late Betty Winston. Wish I had something particularly wise to say to your honors, but I think this is a pretty straightforward case. As Ms. Barnett said, Miss Allison Winston was not removed for any form issues in her accounting or not be able to get the accounting in the proper form. She was removed as conservator because Judge Morgan found that she had breached her fiduciary duty by making these improper transfers to herself that Ms. Barnett discussed. So this isn't a form over substance. Judge Morgan's ruling was based entirely on the substance of these transactions. He held several hearings. Ms. Winston had several opportunities to provide any evidence regarding these transactions. He was able to evaluate the credibility of the witnesses, and he made his ruling. No record was preserved by Ms. Winston, and no statement of evidence was submitted. And in fact, she hasn't even identified any particular transactions where she says Judge Morgan got it wrong of, hey, this transaction was actually for the benefit or should have been approved because of this. She just says, well, I'd made these kind of transactions before and none of the other judges had objected to them, so therefore I should be allowed to continue doing that.
How far did Judge Morgan go back?
2019.
He did not, Your Honor, and I can pull that out, but he specifically says in his rulings that the prior accountings were approved by Judge Butler, and I believe maybe Maroney approved some, and I apologize, I did not represent my clients in the trial court. But he said, this is only for the current accountings. and that is in the final order. So he did not go back and look at anything in those previous matters.
So we're only dealing with one accounting period?
I believe it's the last 2 6-month periods, the last 3 6-month periods. But he specifically states in there that the previous accountings were approved by the previous judges, and then he's not going back and looking at that. I think there may have been some statute of limitations issues. If he had attempted to do that, I think there probably would have been some transactions that could have been questioned if he had done that. Ms. Winston also makes the argument that she and her mother agreed that it was okay for her to take this money. Well, her mother was the ward of a conservatorship. She had been found to not be competent to make those decisions. And Ms. Winston was one of the people that said she needed that conservatorship. So as the court pointed out with the attempts to transfer the car and the attempts to set up the trust, she no longer had the mental ability to make those decisions. As Ms. Barnett pointed out, if it were being treated as fees to be paid to the conservator, those have to be approved ahead of time. That's 111. 112 does allow transactions for the benefit of the ward to be approved after the fact, but not fees for the conservator. So, again, she never made any application to pay herself. She's not questioned any transactions. There's no transcripts. There's no statement of the record. It's just a general, hey, I did this before, so I should have been allowed to do it. Judge Morgan, again, held several hearings. He heard from the witnesses. He had a chance to evaluate the credibility. He appointed Ms. Barnett, who was an independent, had no interest one way or the other in any of the issues between the siblings. She very carefully went through these accountings and the financial records, and his findings should be affirmed. Thank you.
Thank you.
May it please the court, my name is Jennifer Sherman-Schnall of the law offices of Manier and Herod, and I represent State Farm Fire and Casualty Company in this matter. State Farm's sole involvement in this case is as surety on the conservatorship bond. Appellate Winston appeals the final judgment of the General Sessions of Madison County, Tennessee, Division II Probate Section, which ordered her to reimburse the conservatorship account and called upon the bond. The probate court also found the bonding company, State Farm, entitled to judgment against Appellate Winston pursuant to Tennessee Code annotated Section 25-3-122, and this court should affirm that decision in favor of State Farm. The probate court proceedings resulted in a February 10, 2025 order, which stated in relevant part, Allison Winston is ordered to reimburse the conservatorship account in the full amount of $33,885.25 within 30 days of the entry of this order. To the extent Allison Winston fails to reimburse the conservatorship account within 30 days of the entry of this order, State Farm shall deposit the penal sum of the bond, $25,000, into an interest-bearing account maintained by the clerk of the court. State Farm Fire and Casualty Company's motion for judgment against Allison Winston is granted, and judgment is entered in favor of State Farm Fire and Casualty Company against Allison Winston for any amounts that State Farm Fire and Casualty Company is required to pay under the bond, if any. Judgment in favor of State Farm for Appellate Winston's indemnity obligations presents a straightforward application of Tennessee statute, and Appellate Winston's arguments against the statute's enforceability are without merit. Section 25-3.
The $25,000 was the limit of State Farm. That was the total amount
That's
of the
correct.
bond.
The penal sum of the bond was $25,000.
So there was extra that was still left that had not been reimbursed to the state.
That's correct.
Okay.
Sureties are entitled to judgment by motion against their principals, as the statute states, whenever judgment has been rendered against them as such sureties, and whenever such judgment or any part thereof has been paid by the surety. As shown by the record, Appellate Winston failed to reimburse the conservatorship account within 30 days of the entry of the order, and by letter dated April 7, 2025, counsel for State Farm sent a $25,000 check reflecting the penal sum of the bond to the probate court. The probate court received the check on or about April 9, 2025. It is undisputed that State Farm as surety issued a conservatorship bond naming Appellate Winston as principal with a penal sum of $25,000. And it is undisputed that the judgment was rendered against State Farm as surety and that State Farm paid the judgment. Thus, State Farm filed its motion for judgment pursuant to Section 25(3)(122), and the probate court properly granted it. Appellate Winston has cited no authority that stands for the proposition that indemnity obligations do not exist for conservatorship bonds absent an indemnity agreement because no such authority exists. Her argument that she at all times acted in good faith is immaterial and irrelevant to her indemnity obligations to State Farm. As such, State Farm respectfully requests this court affirm the judgment in favor of State Farm against Appellate Winston for any amounts that State Farm is required to pay under the bond, if any, as set forth in the probate court's February 10th, 2025 order. Thank you.
Thank you. Ms. Winston.
First of all, I would like to respond that the money that I received from the wrongful death lawsuit for my father, that was paid back to the estate. So Judge Morgan honored that. I was not working. I had lost my mother, and he wanted all this money in 30 days. I couldn't go get a loan. So she divided her belongings 3 ways. At the end of the court in April, I made an announcement that if my siblings, I was not a moving company, if they wanted to come get things out of the house, they were welcome to do that. No one showed up. Improper transactions were things like she paid for my storage in California because I literally moved here, and things that she wanted to help me with. I had no need to make improper transactions. A lot of these transactions, my previous judges did approve. I do not think that there was a statute of limitations, and I think that the court definitely needs to look at. For 5 years, I never had a problem with any of my accounting. And no, I did not know, and maybe that's not good enough answer, that I had to do this. My siblings had said in court numerous times that I could have the house. My mother left me the house. I had given up everything in Los Angeles. And yes, she paid for things for me, but I was helping her with no money given to me. I know that in the state of Tennessee, you can make $58,000 as a conservator. I didn't do any of that. As far as the house is concerned, I left here at 18, and having a home in Madison County, no offense to folks that live here.
You said in Tennessee you make $58,000 as conservator?
As a conservator.
Okay, that's what, who pays that?
Who pays for that?
Yeah.
Usually the person that you're a conservator for.
Okay.
My mother didn't have that.
Okay.
I got her the VA money just to pay me and to also help pay for her things. But during the appeals trial, it was during COVID, I was in Los Angeles with my mother. We decided to protect my mom, that we would take my father, who had passed away, off of the deed. And I was thinking of any way, in case I lost the conservatorship, that would protect her, because my siblings wanted her in a nursing home and they needed that house. So yes, I put my name on that house. My mother was mentally fine as far as making decisions. She just couldn't talk. So we took my father off, put me on to protect from anyone selling that house, because they weren't going to get it through me. And so as far as I know, down in the deeds office, it's still that way. And again, yes, I put my name on there to protect my mother so that house would never be sold and she would always have it. And I hate to toot my own horn, but if it wasn't for me, there wouldn't be a house to divide between the 3 children, which Judge Morgan did. I might add in closing that I am still unemployed. I'm working part-time here in Jackson, but I'm in forbearance in my parents' home of 48 years, and I have 2 other owners, mainly my siblings, that do not help me on any level. I cannot get another probate judge, so I would like the AOC to help me, if possible, to get me a judge, because, they don't help with anything on this house. And I have struggled for a year and a half to do everything I can. This is my home now, And I gave up everything, and, you know, I am not the person that Judge Morgan wanted me to perceive. I didn't do anything, you know, out of the ordinary, except for things that, yes, my mother paid for, so I could take care of her. Thank you.
Thank you. As I mentioned earlier, we will take this matter under advisement, enter a written opinion, and hopefully do it as soon as possible. I think that concludes the call of the docket for today. We'll be in recess to the call of the docket in the morning.